For judgment at 7/15/2025.
As a cumulative effect of the aforesaid findings, the impugned judgment of the learned trial court is upheld except to the extent of modification of share as indicated by deciding the point of determination number 5. Consequently, half share 6/12 of the suit property would go to the plaintiff number 1, 2, 3 along with defendant number 9, 10 and 11. This appeal is disposed of in the proceedings. आपको क्या बोलना है? This is not the mention time, ना?
Not mentioning time, but
please don't mention. क्या कुछ एडमिशन करना है?
Admission में
serial number 60.
Formal admission है? Other side has not appeared. Otherwise, it is in order. Otherwise, in order.
Yes.
Item 60.
The matter arises out of what case?
Of judgment dated 23/5/2025 in original suit number 14 of 2020.
What is the matter?
Because the suit value is exceeding, it is of 66 lakhs. Therefore,
No. What was the matter?
It was for the declaration of right, title, interest, and providing the possession effective and the valid purchaser of the property. However, that has been only recognized to the extent of 35 decimals out of the 70 something decimals that I have purchased. That has been rejected.
What is this IA? So this is
IA
for
is
interim release.
the ignorant.
FA 123 of 25.
Yes.
Also for the appellant is present. This appeal is yet to be admitted. All defects have been removed. Admit, issue notice to the respondents for which requisites under ordinary process and speed post be filed by the appellant within a period of 1 week from today. Let the records be called for from the concerned court. Pose this case on 13th October, awaiting service record. Office to tracks the case and prepare an appropriate office note with regard to service of notice. You content concern.
Mention case item 59, content 06/05 of 2024.
Order has been complied. Complied.
Your ladyship, our LPA has been dismissed. We are in the process of complying. I am paying for 2 weeks time.
किस लिए आपको टाइम चाहिए? 2 weeks.
To comply, 50% back wages के साथ इनको
हाँ तो इसके लिए आपको 2 weeks क्यों टाइम चाहिए?
Your ladyship,
सब कुछ रेडी है और सब कैलकुलेट किए हुए हैं.
अप्रूवल के लिए थोड़ा सा टाइम लगता है
हाँ?
इसमें बोल रहे थे.
अब क्या चीज़ का अप्रूवल चाहिए? कोर्ट का अप्रूवल है, बात करता मैं. Who has the jurisdiction to deny approval to you?
नहीं उसके लिए
फिर क्या चीज़? अभी सुप्रीम कोर्ट जाने का मन है तो बोल दीजिए, हम लिखा देंगे यही. There is no problem about it. If you want to go to Honorable Supreme Court, we'll give you 1 month time. लेकिन अगला बार ये मत बोलिएगा कि आपको सुप्रीम कोर्ट में.
we have talked to them and they said कम्युनिकेट कर दिए, बता दिए कि हम लोग का डिसमिस हो चुका है, आप इसको कंप्लाई करिए. कुछ ऐसा ऑर्डर भी डिवीजन में से अपलोड हो चुका है एंड दे आर सेइंग ठीक है आज के लिए बस 2 हफ्ते का टाइम ले लीजिए, कंप्लाई.
सारा कुछ कैलकुलेट किया हुआ है लॉर्डशिप. 1 वीक का टाइम दिया जाए. पेंशन कम पे कर रहे थे इसलिए हम डिनाई किए थे, इसलिए लोग
आपको 12% इंटरेस्ट भी देना होगा. You can't forget that.
ये लीजिए.
Learned counsel for the parties are present at the request of the opposite party. The matter is directed to be posted on Monday next.
Problem
Taken
nice.
up at 2:15 as the first case. The opposite party shall ensure compliance of the order passed by this court in letter and spirit as much time has elapsed from passing of the order in the court. The order also indicates that interest is also required to be paid. आप एक्स एम्प्लॉई हैं कौन है एक्स एम्प्लॉई हैं यू वर डिसमिस्ड
डेट ऑफ बर्थ में डिसमिस सुपरिनवेट कर दिए थे wrongly.
The amount payable to the petitioner should be credited to his account prior to the next payment. The calculation sheet of the amount should be produced before this court on Monday.
लॉर्डशिप पेंशन का भी कैलकुलेशन होना चाहिए. पेंशन 5,000 रुपये कम कैलकुलेट किए थे इसलिए हम लेने से मना किए थे और हमको 5,000 रुपये हर महीने कम मिलता है इसलिए हम नहीं लिए.
वो हम नहीं जानते आपका जो ऑर्डर होगा उसी में होगा बाकी पेंशन का लड़ाई है तो अगला रिपोर्टेशन करेंगे. मंडे
Item 1, second appeal 67 of 1997.
Monday would be 25th.
I have my not almost completed.
Yes, you have completed. Respondent बताइए.
My first submission will be lordship. So far the exhibit 2 Sada Nama is concerned, it has got no legal entity. Since after vesting of Jamindari and enactment of the Bihar Land Reforms Act 1950, the entire Garmajurwa Khas land that was vested with the state of Bihar. The lordship, in this context, Bihar Land Reforms Act is citing certain Bihar Land Reforms rules, lordship.
This is गैर मजदूरवा आम
Garmajurwa Khas land. Garmajurwa Khas land as recorded in the revenue register. So, Garmajurwa Khas land after enactment of the Bihar Land Reforms Act, it vested with the state of Bihar. And the intermediaries on the for the lordship ex-Jamindar, Bihar Land Reforms Rule, Section 4 may be seen.
रूल 4 देखें कि सेक्शन 4 देखें.
बिहार लैंड रिफॉर्म रूल का 4.
रूल 4
जी हाँ, रूल 4. Just I am reading this. Form of notice under clauses G, H, HH and I of section 4. A notice under clause G of section 4 shall be in form A. The notice under clause H of section 4 shall be in form B, B1 and B2. Notices under clause HH of section 4 shall be in the form B3 and B4. And the notices under clause I of section 4 shall be in form C. The notices in form A, B1, B2, B4, C shall be served in the manner provided in Rule 3.
आप क्या बोल रहे हैं सर? ये सब का एविडेंस है?
कोई एविडेंस नहीं.
तो फिर आप क्यों ये सेक्शन हमको दिखा रहे हैं?
इसलिए बोल रहे हैं.
सेकेंड अपील में सब्सटैंशियल क्वेश्चन ऑफ लॉ पे फोकस करिए.
Substantial question of law so far is concerned.
ये सब बिहार लैंड रिफॉर्म्स एक्ट पूरा पढ़ाइएगा तो हो गया काम.
नहीं,
फाइंडिंग दिखाइए दोनों कोर्ट का. कोई भी फाइंडिंग ऑफ फैक्ट इज नॉट इन डिस्प्यूट. कोई भी फाइंडिंग ऑफ फैक्ट इज नॉट इन डिस्प्यूट. You show me the finding.
Just I am reading what's in para 20.
Of
Para 20 of the Appellate Court judgment. Now I come to the findings of the court below on issue number 4, 5 and 6 which are being taken together for consideration. It has been submitted on behalf of the appellant defendant that the court below ought to have held that the Hukumnama Exhibit 2 and rent receipt Exhibit 1 series
were forged and fabricated, and same cannot create any title to the plaintiff. The court below further out to have hold that the suit land, including other portions of suit land vested in the state of Bihar, and the plaintiff has or had no title or possession over the suit land. Para 21. No doubt, Sada Hukumnama Exhibit 2 dated 10th March Samvat 2001 can be used for collateral purposes only, and it cannot confer title to the plaintiff. It may not be out of place to mention here the court below has observed that the Hukumnama is supported by Exhibit 1 by A, which is the rent receipt granted by the ex-landlord. Now I am pausing on the ex-landlord. He is the father of the plaintiff. Alku Panjha, he is the father of the Sri Satyanarayan Jha. So they belong to the same family. The father has instituted, give so-called rent receipt in favor of his son, which is the rent is granted by the ex-landlord. It appears from Para 10 of the impugn judgment that the court below has wrongly observed that Exhibit 1 is the rent receipt dated 15/2/63 granted by the state of Bihar in favor of the plaintiff with respect to Jamabandi number 58 for an area of 2.50 acres. As a matter of fact, there is no case of the plaintiff that any vesting return, this part is improved, any vesting return with respect to the suit land was ever filed or submitted after vesting of Jamindari in the state of Bihar. Lordship, here under section 7B of the Bihar Land Reforms Rule, Form K is required, and after acceptance of the same by the government, Form M is issued, that is 7I, Lordship. It has not been followed in this case, Lordship. It may not be out of place as Jamabandi number 50 referred to Exhibit 1 by A is with regard to khata number to which the suit plot apported. In this
नहीं
context,
आधा ऐसे नहीं, आधा वर्ड को खा के मत पढ़िए,
नहीं।
ठीक है, आप एकदम ध्यान से पढ़िए. As a matter of fact, there is no case of the plaintiff that any vesting return with respect to the suit land was ever filed or submitted after vesting of zamindari in the state.
Yes.
It is also not the case of the plaintiff that zamindari, that jamabandi.
any Jamabandi.
Yes, read it please.
Any Jamabandi was opened in favor of the plaintiff, and that also bearing number 58 in the demand register or register. 2. It may not be out of place to mention here the Jamabandi number 58 referred to mentioned in Exhibit 1 by A is with regard to khata number to which the suit plot appertains. In this context, it will not be out of place to mention here that the plaintiff Satyanarayan Jha has himself not come to the court dock to support his case, and there is no explanation for his non-examination.
आगे.
He could have been the most competent witness on the point of settlement or submission return of the suit plot in his favor. His son, Sir Harinder Nath Jha, PW1, stated at the time of his evidence recorded on 16/2/93 that his father was not maintaining good health at the time of his examination, and as such he used to make patry in the case on his behalf. Admittedly, the father of the plaintiff was the ex-landlord, and therefore the creation of Exhibit 2 or Exhibit 1 by A granted by the intermediary for vested purpose cannot be ruled out. And it has to be examined in the light of the fact as to whether any vesting return was ever submitted or filed in his favor at the time of vesting of Jamindari in the state of Bihar, especially in the context of the special provision made for such case in Chapter 2 of the Bihar Land Reforms Act 1950. The learned advocate to the referred to Section 3B, Roman 3, which is as follows. On publication of the proclamation, every intermediary shall at any time before expiration of the said period make to the collector an application in the form set out in the schedule of this act. He has further referred to the statement 1, which is the form of particulars to be furnished under Section 3B, Roman 3, bracket of the act, the column 8 of which form has been specifically prescribed for the area under khas possession of the intermediary, together with plot number and classification of the land. Similarly, column 9 of the form refers to Garmajirua Malik, and together with plot number and column number 13 refers to the total annual rent payable by the intermediary, subordinate tenure holders and rayers. Now, Lordship, in next para 22. The learned advocate for the appellate has rightly submitted that while referring Section 4 of the aforesaid Act, that all the rights of the intermediaries are absolutely vested in the state, free from all encumbrances, with effect from the date of vesting, and such proprietor or tenure holder cease to have any interest to such estate or tenure other than the interest expressly saved by or under the provision of Bihar Land Reforms Act. He has further submitted that the suit land was actually settled by ex-landlord Alku Pant Jha in favor of the plaintiff. There was no question of non-submission of vesting return at the time of vesting of Jamabandi. There is also no case of the plaintiff that any return to that effect was ever submitted or any Jamabandi was opened in his favor. Therefore, Exhibit 1, rent receipt has got no evidentiary value which may have been created purposely. As a matter of fact, this submission made on behalf of has much weight. Para 23. As against this, before discussing the documentary evidences filed on behalf of the contesting defendants so far, their case of settlement of the suit land in their favor is concerned, it may not be out of place to mention here that the description given in the land and the written statement are distinct in respect of boundary but identical in area, plot number and khata number. It appears from the Parwana, Exhibit C, dated 2
We are not concerned with rest of the findings.
Rest of it.
We are only concerned with the zamindari,
Jamindari,
the hukumnama and the rent receipt.
rent receipt.
So the learned appellate court has disbelieved these two documents.
Disbelieved. In fact, Lordship, after enactment of the Bihar Land Reforms Act, the ex-landlord Jamindar did not perform his duties or obligation for submitting return in respect of the land in question, and that the inference was drawn that the land was vested with the state of Bihar. That is the main condition, main contentions. And second point is, Lordship, the plaintiff who was alive at that time, he did not appear to substantiate the statement made in the plaint or make his deposition. And under section 17B of the Registration Act, there is a provision, Lordship, that every property having value more than 100 rupees must be
Where is
registered.
the finding on possession? Where is the finding on possession?
Para 24. So far coming into possession by defendant number 2 after the settlement is concerned, the rent receipt exhibit A series referred to above raises a presumption in favor of her possession.
आपका केस में कुछ हो नहीं सकता. There are findings of facts recorded by the court. Right.
Kindly see the appellate court issue of the force of Jamabandi, force hukumnama was not before.
Need not be there. Hukumnama you cannot rely upon. You forget about.
The hukumnama coupled with the jamindari receipt.
No. So
It
far
is
as
coupled with
jamindari
it.
receipt is
Since my lord,
concerned,
they have not stated anything in WS, nor even they have given in the cross examination or in their evidence regarding the Jamabandi. Reason
you were the plaintiff.
I am the plaintiff.
You have to make out your own case.
I have made out my case.
You see, it is just one isolated zamindari rent receipt, and thereafter, which is the earliest rent receipt? Which is the earliest rent receipt thereafter? उसके बाद
बिहार का ये वेस्ट कर गया, वेस्ट करके बाद बस बिहार सरकार का रेंट
ने
रिसीट
पहला रेंट रिसीट को डिसबिलीव किया है, उसका फाइंडिंग को हम डिस्टर्ब नहीं कर सकते.
तो पहला रेंट रिसीट जो बिहार का जो रेंट रिसीट को डिसबिलीव किया था, हम उगनी देवी के केस में जो कर रहे हैं, माई जमींदारी रसीद.
उसके बाद आपका सबसे पुराना रेंट रिसीट कहाँ है? आपके नाम से कभी जमाबंदी खुला है?
मेरे
You
नाम
see,
से
after the vesting, right? There is a procedure for opening a jamabandi.
My lord,
Right? Has that procedure been followed in your case?
according though since it was not challenged, that's why
Need not be challenged.
It has not
You
been
have
brought
rent
on
receipt
record.
without any jamabandi.
नहीं, मेरा जमाबंदी के बगैर कैसे बिना रेंट रिसीट होगा?
No, तो वही ना.
They are challenging this.
No.
My lord, only the substantial question of law in this
We'll see
case
that.
ki whether the सादा हुक्मनामा coupled with जमा rent stated a giving possession.
सादा हुक्मनामा coupled with one isolated rent receipt is not sufficient. It has to be followed by consistently issuance of rent receipt, recognition by the state. उसके बाद जो एग्जिबिट 1 को डिसबिलीव किया गया है, उसके बाद आपका लेटेस्ट रेंट रिसीट कौन सा? बताइए.
1 मिनट समय दे सकते हैं?
बताइए.
1 मिनट.
ठीक है, पहला वाला हम मान लेते हैं कि भाई कोड बोल दिया कोड, उसके बाद कौन सा एंट्री सीट है आपके पास?
एक मिनट
बताइए।
ही इज नॉट कंफर्म बोले कि हम देख के
कंफर्म
बता
नहीं
सकते
होगा,
हैं
वो
इसके
तो
बाद।
आपसे सवाल पूछेंगे, आपका जवाब आपके फेवर में नहीं होगा तो आप कंफर्म नहीं होंगे। ये सब कहानी थोड़ी सुनेंगे आप।
अपार्ट फ्रम दैट
और आप उनसे क्यों पूछ रहे हैं?
Possession-
रिकॉर्ड आपके पास है,
Possession-
आपका ओल्डेस्ट रेंट रिसीट इज ऑफ द ईयर 1993। 30 साल का है।
93 मैडम।
यस 93 नहीं 93 नहीं
63
नहीं नहीं 63 तो वन है,
वन
वो तो डिसबिलीव कर दिया है।
डिसबिलीव हो गया।
उसके बाद वाला रेंट रिसीट कौन सा है आपका?
वो तो दो उसके बाद वाला तो जमींदारी रसीद है 1 बाय।
अरे भाई उसके बाद वाला जमींदारी रेंट रिसीट नहीं है। इन पॉइंट ऑफ टाइम 63 का रेंट रिसीट आपने क्लेम किया,
जी।
which has been disbelieved by the learned appellate court.
Right
Right?
appellate on the point
Whatever be the point, that is not the substantial question of law before us. Right? उसके बाद आपने और भी रेंट रिसीट प्रोड्यूस किए हैं
नहीं, यही 2 एग्जिबिट है। एग्जिबिट हम यही 2 एग्जिबिट लेके आए हैं।
और उसके बाद कुछ नहीं।
नहीं, एग्जिबिट 2, एग्जिबिट 1 एंड एग्जिबिट 1 बाय ए।
बस 2 रेंट रिसीट। 63 का रेंट रिसीट में आप सूट का फाइल किया
सूट हम 91 में।
91 में, उसके बाद इस बीच कोई रेंट रिसीट नहीं कटा। There is no rent receipt thereafter. There is
Yeah.
no continuous possession of yours.
Yeah, I am in continuous position.
What do you
Apart
mean you are
from
in
that, kindly
continuous?
see my lord. So far,
Lordship, just one minute. The prayer which he has made in the plain, recovery of possession.
no. If recovery of possession,
Roman 3, recovery of possession. If during pendency of the suit,
my lord,
the plaintiff be dispossessed or found to have been dispossessed, then the khas possession be given to the plaintiff.
क्योंकि हम पोजीशन में थे, अगर
हाँ।
ड्यूरिंग द पेंडेंसी हमको डिस्पोजेस कर दिया गया तो हमको पोजीशन वापस दे दिया जाए। दैट इज माय एंसिलरी।
One mean का prayer है, possession of the suit land be declared and confirmed. Plaintiff. He was not in possession of the land.
I was in possession. Kindly see the report of the pleader commissioner. प्लीडर कमिश्नर के रिपोर्ट में भी आया है, ये भी लिखा गया है कि जो मेरे से बचा अगर 2001 में आइसोलेटेड हमको मिलता है एक जमाबंदी हुक्मनामा, then matter would have been different. उसी समय तीनों भाइयों को मिला है हुक्मनामा, जिसमें एक भाई से ये खरीदे हैं।
ये जो यहाँ पे इतने सारे रेंट रिसीट एग्जिबिट किए गए हैं, ये किनके रेंट रिसीट?
ये इनके रेसिट्स
Defendant का है।
डिफेंडेड के हैं
Defendant
और कहते हैं कि 75 में
एग्जिबिट A/2,
हाँ, ये
दी अल्टरनेटिव
A/5,
ये सब इनका है।
आपने सिर्फ 2 ही अपना रेंट रिसीट,
रेट्स
उसमें से एक डिसबिलीव हो गया।
disbelief.
that is the fact by the appellate. Apart from that, my lord, the land जो है मेरा जो डायमेंशन दिया गया है, बाउंड्रीज जो लैंड का दिया गया
उस पर कोई डिस्प्यूट नहीं।
रीजन इसलिए कि
That
इनको
is
अगर
not the
सेटल
substantial question of
इनको
law.
अगर सेटल भी हुआ होगा, दैट इज नॉट माय लैंड। काइंडली सी द रिपोर्ट ऑफ द प्लीडर कमिश्नर। उन्होंने लिखा है कि मेरे जमीन के बगल में इनका जमीन है, जिसका 1 और 3 से लेके 8 7 तक 6 तक ये कब्जा करने की
कमिश्नर का
कोशिश।
रिपोर्ट नहीं देख सकते हैं आप, जजमेंट से दिखाइए। जजमेंट से दिखाइए कि आपका सूट प्रॉपर्टी से इनको कोई लेना देना नहीं।
उसको हम दिखा देते हैं।
बस उतना फाइंडिंग दिखा दीजिए, हम लिखा देंगे।
सबमिशन इन डिपोजिशन है,
Submission नहीं।
ट्रायल कोर्ट में
फाइंडिंग दिखाइए,
Trial
डिपोजिशन,
में
सबमिशन।
D7 जो है अपने कहीं है, जो डिफेंडेंट
देखिए,
नंबर 2 है।
जस्ट अ सेकंड, आप इतना सेकंड अपनी बहस करते हैं, आपको नहीं पता है जितना बना है उसी के 4 कोने के अंदर आपको रहना है। उसके बाहर ट्रैवल करिएगा तो मेरा ऑर्डर परवर्स हो जाएगा, 1 मिनट में सेटिस्फाई हो जाएगा। चाहते हैं ऐसा ऑर्डर?
नहीं मैम,
तो बस
इसमें खाली जो डिपोजिशन है डिफेंडेंट
नहीं
नंबर
देख
2
सकते
का
ना।
ये
You see,
defendant
there
number
is
2
a finding of fact of possession against you. The possession has been found against you. अब क्या बचा है? अगर आप पोजीशन में हैं, just a moment, अगर आप पोजीशन में हैं, you enjoy the possession. आपको प्रॉब्लम क्या है इसमें?
apart from that kind
नहीं, आप if you are in possession,
my lord, as per my
whatever be the declaration, you enjoy the possession. They will file a suit for recovery of possession. इसमें क्या दिक्कत है?
अच्छा, इनका जो पोजीशन अपलेट कोर्ट जो हेड किया है वो प्रिजम्पशन पर किया है, चूंकि
किसी
इनका
पर भी किया है,
रसीद-
that is
रसीद
not
काटा
the
है।
substantial question of law. I
That
will
is not the
do that.
substantial question of law. The only question, only
Counsel, please appreciate.
my lord,
If you are in possession and the finding of possession is against you, right? You enjoy the possession. थोड़े दिन बाद एडवर्स पोजीशन के लिए सूट फाइल कर दीजिए। हो गया बात खत्म। इनका टाइटल भी कहाँ डिक्लेयर किया, इनका तो सेटलमेंट का कहानी क्या क्या बोल रहे हैं,
हाँ पूरा कहानी।
दैट इज देयर ओन स्टोरी, एंड यू जस्ट शो मी दैट फाइंडिंग ऑफ द कोर्ट दैट योर प्रॉपर्टी इज डिस्टिंक्ट फ्रॉम हिज प्रॉपर्टी, वो हम दिखा देंगे।
ये जब इशू नंबर 3 को किया गया है उसमें मेरे डिस्क्रिप्शन को सही माना गया है, जो ये डिस्क्रिप्शन दिए हैं वो डिस्क्रिप्शन को डिसबिलीव किया गया
ठीक
बाय
है।
बोथ दी
ठीक
कोर्ट।
है।
यानी कि जो मेरी सूट प्रॉपर्टी है और जो ये प्रॉपर्टी कह रहे हैं बाय वे ऑफ सेटलमेंट मिला है, बोथ आर द डिफरेंट प्रॉपर्टीज।
नहीं, इसका मतलब हम डेरिवेटिव नहीं करेंगे,
माय लॉर्ड,
हम डिराइव नहीं करेंगे कोई चीज। आप फाइंडिंग दिखाइए that they have not been able to identify their property, right?
they have pleaded कि my property is imaginary.
Okay. They pleaded that your property is imaginary. The court records that you have successfully established your property,
My lord,
the identity of your property.
my lord.
But at the same time, court records that you are not in possession of the property.
Since the
And the
rent
court
receipt-
disbelieves your first rent receipt by the state. That is Exhibit 1. So, on the basis of Exhibit 1 by A, how can your title be declared by this court? On the face of unregistered document. देखिए उग्नी देवी का केस में the contours are totally different. Continuously in possession, continuously in issuance of rent receipts, and the possession was more than 12 years. That has also been taken into consideration. 12 साल से ज़्यादा
My lord,
that lady was in possession of the property, admitted.
1944 में माय लॉर्ड हम आए हैं और 91 में सूट है, उस समय मेरा पोजीशन है, दैट इज माय प्रेयर कि आई एम इन, मेरा पोजीशन को डिक्लेयर किया जाए, एंड इफ ड्यूरिंग पेंडेंसी अगर
हर केस आप नहीं जीत सकते,
My lord,
ठीक है? Let's take it. Somebody has to win. It is difficult for me to enter into any disputed question which does not come within the contours of the substantial question.
my lord.
इसीलिए बार-बार आप लोग को बोलते हैं substantial question of law बनाते समय हर चीज़ पर बहुत ध्यान दिया करें। तो आप लोग ध्यान ही नहीं देते। एक एडमिट हो गया, एक बन गया, बहुत हो गया। If he is in possession, let him enjoy the possession. भाई अभी तक तो कोई रिकवरी ऑफ पोजीशन का केस नहीं हुआ
फाइनली ये
ना।
17 तक का रसीद है मेरे पास, जैसा इन्होंने
ऐसा नहीं है ना, 17 तक का पॉकेट में रखे नहीं है, उसका हम लोग क्या ही कर सकते हैं। Second appeal number 67 of 1997 within bracket R. For the learned counsels appearing on behalf of the parties. This appeal was admitted by the order dated 2/3/1998 on the following substantial question of law. The learned counsel for the appellant has submitted that the case of the appellant is fully covered by the judgment passed by Honorable Patna High Court full bench in the case of Ugni Devi and others versus Chauwa Mehto, reported in AIR 1968 Patna 302, and he submits that even if it has been held that though Sada Hukumnama being unregistered is inadmissible in evidence, but the other facts and circumstances of the case is required to be considered to deal with the possession and the rights of the parties. He has submitted that in the said judgment, the possession and rights of the parties has been duly considered in spite of holding that Hukumnama was inadmissible in evidence. While referring to the facts of the case, the learned counsel has submitted that the plaintiff had produced Hukumnama along with one zamindari rent receipt. Issued by the zamindar who was his father. The learned counsel has submitted that that the Hukumnama as well as Zamindari rent receipt were marked Exhibit 2 and 1 by A respectively. Exhibit 2
Yes, ma'am.
was dated
That is 10 Magha Suddhi 2001 Samvat.
was of the year 2001 Samvat, which is equivalent to the year 1944, and the rent receipt was dated.
वो रेंट रेसिड 2010 का था वो that is 9/7/44
15 का है।
The rent receipt was of the year 2010, which is of the year 1957. Correct?
1953.
Which is of the year 1953. The Learned Council has also submitted that based on these documents, the state of Bihar had recognized the plaintiff / his predecessor in interest as Rayyat and issued rent receipt in the year 1963
15
on 15/2/63, which was marked Exhibit 1. The Learned Council has, upon a query of this court, the Learned Council has fairly submitted that apart from these two rent receipts, no other rent receipt were produced on behalf of the plaintiff. But the plaintiff continuously remained in possession of the suit property, and he is still in possession of it. The Learned Council submits that the Learned Trial Court had believed the Hukumnama and the rent receipts contained in Exhibit 2, Exhibit A and Exhibit A by 1, and had decreed the suit on contest.
That is 1 and 1 by A.
Exhibit 1 and 1 by 1. He has further submitted that so far as defendants are concerned, they were claiming the property by virtue of settlement made by the state,
Settlement made by the state as well as the land sold by the Kali Charan Jha to the
as well as,
That is not the suit land.
just a moment, as well as on the basis of land sold by Kali Charan Jha by registered sale deed of the year 1968.
The suit land was based on the settlement, not by the registered settlement.
Okay.
In fact,
Kali settlement
and settlement
by settlement made by the state of state of Bihar,
1975.
and they claimed to be in continuous possession of the suit property. The settlement was in support of the settlement. The order sheet of settlement case number 301 of 7576 / 101 of 7576 were produced before the court. The Learned Council has submitted that the defendants had raised an objection with respect to the identity of the suit property, and both the learned courts have held that the suit property claimed by the plaintiff had a well-defined boundary, and such plea was rejected by both the courts. The Learned Counsel has also submitted that such finding was recorded on the basis of Pleader Commissioner's report,
along with the depositions and the parwana.
along with the depositions and parwana, and in view of the Hukumnama, the Zamindari rent receipt, and the rent receipt issued by the state of Bihar, and also the fact that the plaintiff had established the boundary with respect to the property. The plaintiff had duly proved right title, interest, and possession with respect to the suit property. He submits that in view of the continuous possession of the appellant, coupled with Hukumnama, Zamindari rent receipt, and rent receipt issued by the state of Bihar, the substantial question of law is fit to be answered in favor of the denied, taking into consideration the judgment of Honorable Patna in the case of Urmi Devi. So, the Learned Counsel on behalf of the respondents has opposed the prayer and has submitted that the Learned First Appellate Court has taken into consideration that the plaintiff was the son of ex-zamindar, and that no zamindari return was exhibited before the court in terms of Bihar Land Reforms Act. And the Learned First Appellate Court recorded that the property vested in the state of Bihar. The Learned Counsel has also submitted that so far as the first rent receipt claimed to have been issued by the state of Bihar, that is Exhibit 1, is concerned, the same has been disbelieved by the Learned First Appellate Court. He has also submitted that so far as the possession of the property is concerned, the Learned First Appellate Court has recorded that
Paragraph 24.
as recorded in paragraph 24, that the evidence adduced on behalf of the defendants is much superior as that of the plaintiff. The Learned Counsel has also submitted that. Consequently, the Learned Counsel has also submitted that no documents were produced in connection with creation of Jamabandi in favor of the appellant, nor any document was produced showing continuous payment of rent right from the date of vesting. Rather, only 2 rent receipts were produced, and the rent receipt claimed to have been issued by the state of Bihar has been disbelieved by the Learned First Appellate Court. And so far as the Hukumnama is concerned, the same is inadmissible in evidence, being an unregistered. After hearing the Learned Counsel for the parties and considering the facts and circumstances of this case, this court finds that the plaintiff was claiming the property by virtue of Hukumnama of the year Sada Hukumnama of the year 1944, executed by his father in his favor, followed by Zamindari rent receipt issued 10 years thereafter, in the year 1953.
आफ्टर 9 years सारे साल का 2006 से ऑनवर्ड, उसके पहले 6 का कटा हुआ, that is not on
No,
record.
no, ऐसा नहीं assume नहीं करेंगे ना.
They kindly
The only rent receipt which you have produced.
वो 1953 का है, उसमें किस किस साल का कटा है लिखा रहता है. तो 2006, 7,
ऐसा
8,
नहीं
9
कर
और 10.
सकते. ऐसा नहीं कर सकते. And the appellant has and the plaintiff has produced only one rent receipt issued by Zamindar, which was issued after expiry of 9 years. After expiry of 9 years from the date of Hukunnama, from the alleged date of Hukunnama. This court also finds that, which was marked Exhibit 1 by A. This court also finds that the appellant claimed that the state of Bihar had also issued rent receipt in his favor in the year 1953. 1963. But the learned first appellate court has disbelieved the same.
Without assigning any reason.
आप लिखाइए judgment. Has disbelieved the same.
The exhibit 1.
Just a moment. By observing that the trial court wrongly observed that Exhibit 1 is the rent receipt dated 15 to 1963 granted by State of Bihar in favor of the plaintiff with respect to Jamabandi number 58 for an area of 2.50 acre. As a matter of fact, area of 2.50 acre, the learned appellate court also recorded that as a matter of fact there is no case of the plaintiff that any vesting return with respect to the suit land was ever filed or submitted after vesting of zamindari in the state of Bihar. It is also not the case of the plaintiff that Jamabandi was ever opened in favor of the plaintiff. That also bearing number 58 in the demand register or register 2. The learned court also took into consideration that Satyanarayan Jha himself had not come in the dock, who was claiming the property, who was the plaintiff in the case. At the same time recorded that his son had deposed at PW1 by stating that he was deposing as his father was not maintaining good health. The learned first appellate court recorded that the father of the plaintiff was the ex-landlord, and therefore the Exhibit 2 or 1 by A creates some doubt. And ultimately found that no return was executed, and it was not the case of the plaintiff that zamindari return was ever filed, and referred to the provisions of Section 3B, Roman 3 of the Land Reforms Act. And accepted and was of the view that the entire land was vested in the state under the Bihar Land Reforms Act. The learned first appellate court also recorded that the settlement made in favor of the defendant was never challenged by the plaintiff before any competent court. Correct. Although lot of objection was raised in connection with the correction of in connection with the correctness of settlements so made, including the ground that given number 2 was not a landless lady. The learned first appellate court thereafter considered. The learned first appellate court ultimately recorded a finding in the learned first appellate court also recorded a finding that the exhibit 1 had no evidentiary value and decided the case against the appellant. So far as the possession is concerned, the learned first appellate court also recorded that the evidence adduced on behalf of the defendant was much superior than that of the plaintiff, and consequently the possession was also decided against the plaintiff. This court finds that no substantial question of law has been framed in connection with any perversity with respect to the appreciation of evidence by the learned first appellate court. The law is well settled that the learned first appellate court is the final court of fact and law. Considering the nature of substantial question of law framed, this court finds that the judgment passed by Honorable Full Bench in the case of Ugni Devi does not apply to the facts and circumstances of this case, inasmuch as the learned first appellate court has disbelieved the zamindari rent receipt and the hukumnama, and was of the view that the entire property vested in the state, and also recorded that the plaintiff was not in possession of the suit property. There is no doubt that unregistered hukumnama, as held by Honorable Patna High Court in the case of Ugni Devi, there is no dispute that the unregistered hukumnama, though inadmissible, could be looked into to show the nature and character of possession. And independent of hukumnama, the rent receipt themselves indicate the rate of rain, the area, and the nature of the right of the lessee. Hence, independent of hukumnama, the terms of the royalty settlement were inferable from other pieces of evidence, which in the said case was rightly relied upon by the lower appellate court. This court finds that the lower appellate court has ultimately recorded finding of fact regarding possession against the appellant. And further, this court also finds that apart from Sada Hukumnama and one Zamindari rent receipt, no further documents was available with the appellant to show his continuous possession of the suit. in the case of Bhumi Devi, the court has also taken into consideration that the claimant was already in possession of the suit property for more than 12 years. But no such evidence has been produced before this court. But no such finding has been recorded by the learned First Appellate Court in favor of the claimant. Consequently, the substantial question of law, when seen in the light of the ratio of Bhumi Devi, is answered against the appellant and against the appellant, and the fact remains that the First Appellate Court did not find the appellant in possession of the suit property, and that finding has attained the night. This appeal is consequently dismissed.
At this point, I may add one point, Lordship, just Lordship. In 53, the landlord issued a rate after enactment of the Bihar Land Reforms Act, not in 1942.
बिहार इस सब इशू में मत जाइए. बिहार लैंड रिफॉर्म्स एक्ट का इफेक्टिवनेस अलग अलग एरिया में अलग अलग डेट पे हुआ है, इसलिए बहुत सा केस में 60s में भी हुआ है, केस में 56 में हुआ है. दे हैव अ डिफरेंट डेट. ऐसे नहीं बहस करना, ठीक है? इतना दिन से अभी सिविल बेंच में बैठे नया नया चीज़ों को सीख
तो रामगढ़ राजा माने ही नहीं लैंड रिफॉर्म्स एक्ट.
जब तक जजमेंट नहीं होगा तब तक थोड़ी मानेंगे.
This case item 3, second appeal 484 of 1991.
कोई बात नहीं. 1991 का केस है. पिछली बार जब आप अपील हुए थे तब क्या चल रहा था? यस, पिछली बार जब आप केस में अपील हुए थे तब आपने रिकॉर्ड क्यों नहीं मांगा? और आज के दिन में आपको टाइम चाहिए? किसका कॉपी नहीं है? वो हम लोग क्या जाने आपके पास क्या कॉपी है क्या नहीं. अब बहस करिए. एडजर्नमेंट मांगेगा तो हम बहुत हेवी कॉस्ट करेंगे. 91 का है तो 90,000 कॉस्ट तो होना ही चाहिए.
हुजूर एक सबमिशन केवल एक
आपका कोई एडजर्नमेंट के अलावा सब सबमिशन.
हुजूर हमको यस्टरडे आपको फाइल मिला है. आई हैव गॉन थ्रू द एंटायर ब्रीफ. आई हैव फाउंड दैट द प्लेंट एंड द WS is missing in my file. And my lord, kindly appreciate, my lord, that
I will appreciate everything, but adjournment will be given only on payment of cost.
हुजूर इसको 2 दिन के बाद रख
2 दिन बाद हमें तो नहीं पता हम रहेंगे कि नहीं रहेंगे. आपको पता है? कुछ नहीं. 91 का मैटर पास ओवर भी नहीं होना चाहिए. नहीं सुनेंगे आपका ऐसा बहाना. कोई एडवांस नोटिस नहीं है एडजर्नमेंट का. आप इस तरह से एक केस जो फिक्स है 2:15 बजे के लिए, आप उसमें खड़ा होकर टाइम मांगेगा कि आपको अभी वकालतनामा मिला है?
नहीं, हमको वकालतनामा नहीं मिला है.
क्या मिला है?
My lord, he has interested in the brief on yesterday.
तो कोई बात नहीं, कल आप दूसरे को इंटरेस्ट कर दीजिएगा.
इंटरेस्ट नहीं.
हम टाइम नहीं देंगे.
On the basis of the material available on the record, I am going to argue the case.
Time rejected.
My lord, on the
Adjournment
basis,
is absolutely rejected.
then I am not seeking adjournment on the
You
basis of the material available on the record.
I do not.
I pursue
Every
the-
material is available on record because the entire case record is here. सुबह 10:30 बजे से क्या कर रहे हैं आप? बताइए.
2:15
3:30 बज गया.
नहीं हुजूर 2:15 का टाइम था, इसीलिए हम
इसीलिए 2:15 में याद आया कि मेरे पास रिकॉर्ड नहीं है.
नहीं हुजूर हम 10:30 में इसीलिए मेंशन नहीं.
मेंशन क्यों करना है?
फॉर सीकिंग एन एडजर्नमेंट.
नो, एडजर्नमेंट के लिए नहीं, रिकॉर्ड देखने के लिए. हम कहाँ बोल रहे हैं आपको एडजर्नमेंट देंगे?
तो हुजूर ऑन द बेसिस ऑफ मटेरियल
आपको जो बहस करना है करिए.
आई विल आर्गू.
आगे.
My lord, the instant second appeal is against the judgment of reversal. The suit of the plaintiff. I am for the defendant in the suit, my lord. Suit of the plaintiff. Plaintiff claiming her right and title on the basis of custom prevailed in the Santhal Pargana that she solemnized Gharjamai form of marriage with one Devi Murmu, who is dependent, who is
Plaintiff is a male or a female?
the plaintiff is a female, my lord, Surajmani Hansda.
She says that she is Gharjamai form.
Gharjamai form. With one Devi Murmu, who have been arrayed as plaintiff number 2.
Plaintiff number 2.
And the relief claimed, relief sought in the,
आप क्यों खड़े हैं? बैठ जाइए.
and the relief sought for in the plaint. My lord, I am just pointing out the relief, what the relief has been claimed for by the plaintiff. That this is a suit for declaration of title and recovery of possession of the suit property mentioned in Schedule C of the plaint.
She claimed title of the property.
Declaration of right title and for recovery of possession appertaining to only Schedule C property.
There is no prayer for confirmation.
And my lord, after scrutiny of the evidence, oral and documentary evidence, my lord, learned trial court dismissed the suit of the plaintiff, holding therein that the plaintiff has failed to prove the custom for her entitlement with the property of his father.
Failed to prove the custom.
That has been asserted by filing.
If she failed to prove the custom,
My,
they will be guided by ordinary law.
but my lord, so far the customary law, SPT Act is concerned.
आपने प्रूव किया था कि they are governed by this Gharjamai form.
No,
Yes.
it is the burden is upon the plaintiff, my lord, because the plaintiff has filed a suit claiming the right title on the basis of Gharjamai form of.
This
marriage.
custom, it was their pleading.
It was their pleading.
Okay. She failed to prove the custom.
She failed to prove. My lord, against the judgment passed by the subordinate court, my lord.
Where is the finding?
My lord.
Trial court ka finding.
Trial court, my lord, before adverting to the finding, my lord, I would like to refer the issue formulated, recast by the trial court, that is internal page 9 of the trial court judgment.
Yes, and there. Which issue are you referring to?
My lord, here, my lord, out of my lord, the 6th issue, my lord, the very important issue, that is issue number 4. Entire dispute is revolving around this issue, my lord. Whether Ram Hansda is the father of plaintiff number 1, whether Ram Hansda brought his daughter Surajmani Hansda, plaintiff number 1, and her husband, plaintiff number 2, in Agumit Gharjamai in 1357. Yes, it corresponds to 1950, as asserted by the plaintiff or plaintiff of plaintiff. Surajmani Hansda was married to plaintiff number 2 in Saga or Chumna form, which was never converted into Agumit Gharjamai as alleged by the defendant. My lord, this issue, and on this issue the appeal was admitted. Filed order dated, my lord, 28/1992. The substantial question of law that was formulated by the court, kindly have a glance to the substantial question of law. Order number 5 dated 28/1992.
Yes.
The substantial question of law involved in this appeal is whether the marriage in Agumit form can be equated with Gharjamai form of marriage amongst the Santhal.
What is Agumit?
Agumit form होता है हुजूर,
Record से दिखाइए.
हाँ?
Common sense, common knowledge नहीं चलेगा. Record से दिखाइए. What is Agumit form?
यह डिस्कशन किया गया है
दिखाइए वहीं से
Judgment.
दिखाइए. क्योंकि ये सारी चीजों को कस्टम की तरफ प्रूव करना पड़ता है.
हाँ, तो ये तो प्रूफ करने का तो ड्यूटी प्लेंटिफ पे है ना.
She claimed that it is Agumit
Agumit.
Gharjamai form.
Gharjamai form.
That was a plaint.
That was the plaint.
Did you say that augment Gharjamai form is not the same as Gharjamai form?
Yes,
Where is your statement?
in the WS, my lord, I have.
Yes. ये से सारा कुछ देखिए पुराने जमाने में सब कुछ लिखा ही रहता था. Impugned judgment में आपको सब मिल जाए.
इसीलिए जो हम इशू नंबर 4 है रेफर कर चाह रहे हैं, इशू नंबर 4 में ही इसका डिस्कशन.
चल पढ़िए.
मतलब इशू नंबर 4 स्टार्ट फ्रॉम इंटरनल पेज 9.
हाँ पढ़िए.
According to the Santhal customary law of inheritance, girls is married in Gharjamai form is entitled to inherit her property, father property, and in case of Santhal girl who is married in Chuman or ordinary form is entitled to inherit the property of her. It is stated in para 16 of the plaintiff that
And एक सेकेंड ये आगा पढ़े.
यहाँ हुजूर कुछ
A girl
जजमेंट है ना, हुजूर 1983 का जजमेंट है.
is married only in Gharjamai form is entitled to inherit a father's property, and in the case and Santhal girl who is married in Tuna or in ordinary form is entitled.
यहाँ नोट इन टाइटल होना चाहिए हुजूर, यहाँ नोट इन टाइटल होना चाहिए.
All right, not ही होना चाहिए.
नोट इन टाइटल होना चाहिए, लेकिन वन नोट इज मिसिंग.
Sentence से भी ऐसे ही लगा.
Not entitled to inherit the property of father. It is stated in para 16 of the plaintiff that Ram Hansda brought his daughter Surajmani Hansda and her husband Devi Murmu in Agumit Gharjamai in the year 1357 BS corresponding to 1951 AD and executed a Gharjamai paper on 9th Asar 1357. The learned lawyer appearing on behalf of the plaintiff submitted that Ram Hans, the father of the plaintiff number 1, Surajmani Hansda was not old at the time of the marriage of her daughter with Devi Murmu, plaintiff number 2, and when he lost all hope regarding a male child being born at the old age, he executed a Gharjamai paper in favor of his daughter and son-in-law with a condition to nurse him in old age and to look after his property after his death. This argument of the learned lawyer for the plaintiff supposes that there must have been long gap between the marriage of plaintiff number 1 with plaintiff number 2 and the execution of the Gharjamai deed exhibit 1. PW1 is plaintiff.
ये आर्गुमेंट में कहाँ से आ रहा है? ये तो प्लेंट में होना चाहिए ना.
इसीलिए हम जो एट द वेरी आउटसेट हम रिक्वेस्ट केस की
नहीं, इसी से पढ़िए ना प्लेंट में क्या केस है. ऐसे आर्गुमेंट में वकील साहब कुछ भी बहस करके नहीं निकल सकते हैं. प्लेंट से बाहर नहीं बहस कर सकते. इसी जजमेंट में पढ़िए.
अब तो जजमेंट में पारा 1 से ही पढ़ दे रहे हैं.
जजमेंट में खाली केस पढ़िए उनका,
ठीक,
क्योंकि ऐसा लग नहीं रहा है कि वकील साहब जो है प्लेंट के अनुसार बहस करते हैं.
इसलिए हम
पढ़िए पैरा 2 पढ़िए.
This is the suit for declaration of title and recovery of possession of the suit property mentioned in the Schedule C of the plaintiff that has been shown in the red map annexed to the plaintiff. The plaintiff and defendant first and second party are Santhal and governed by their customary law of inheritance. Land of Jamabandi number 32 of the village Madhuban correspond to land of Jamabandi number 4 of village Madhuban of MacPherson settlements which belongs to Jharkhand. The property pertaining to Jamabandi number 32 fully described in Schedule A of the plaintiff stands recorded in the name of Abu Hansda and Raman Soren with separate position. The recorded unit Abu Hansda and Raman Soren were Sadhu. Jarku Tutu had no son but 2 daughters. The eldest daughter was
The father of plaintiff number 1 is Jakru Tutu.
Father of plaintiff number 1 is Ram Hansda.
ठीक.
Ram Hansda was the son of Bhaglu Hansda. The recorded tenant Bhaglu Hansda and Raman Soren were Sadhu. Jharkhand Tudu had no son but two daughters. The eldest daughter was married to Bhaglu Hansda, son of Karan Hansda of India, and the second daughter was married to Ramin Soren of neighboring village Kalipathar in Bundelkhand. On the death of Jharkhand Tudu, this took place before the Mr. Ganjar settlement. Separation of the land on the seat Jamabandi number 4 were inherited and occasioned and possessed by Churka daughter and son-in-law according to the Santhal customary law of inheritance and law of succession. After the death of Churka Kuta and before Ganjar settlement, separation property, the land of Jamabandi number 32, plenty partitioned, and one share was allotted to Bhaglu Hansda, his wife, and another to Raman Soren and his wife. He began to possess possession separately. Raman Soren was married in Kundela, Lapan, and so his wife were given approximately 6 annas share. 6 annas share. And Bhaglu and his wife were given approximately 10 annas share in the land of Chutta Tutu, appertaining to Jamabandi number 4 of MacPherson settlement corresponding to Jamabandi number 32 of Ganjar settlement. During the last Ganjar settlement operation, Heba Tutu, brother of Chutta Tutu, and some other objected and claimed the land, but their claim was disallowed by the survey authority, and Bhaglu Hansda and Raman Soren were recorded with separate position with regard to the land of Jamabandi number 32 of village Madhuban. The land they were recording exclusively in possession of Bhaglu Hansda have been fully described in Schedule D of the plan, which were inherited on his death by his 3 sons. Bhaglu Hansda died long ago, leaving his 3 sons, namely Karan, Raman, and Lakhan. Karan Hansda died about 15 to 16 years ago, leaving his 3 sons, Ruplal, Koto, and Munulal. Munulal also expired about 6 years ago, leaving behind 2 minor daughters, namely Mardi and Kasan. Raman Hansda died in the year 1968, leaving the plaintiff number 1 as his heir and successor. Lakhan Hans died in the year 1969, leaving Vivisan Hansda and Srinath Hansda. On the death of Bhaglu Hansda reported in the Schedule D lands were inherited by his 3 sons, and just after a few years of his death, the Schedule D lands were partitioned into 3 shares. 1 share each to Karan, Raman, and Lakhan. All of them then began to produce separately according to their share of the land on payment of rent. The rent was paid sometime jointly and sometimes separately. In the aforesaid partition amongst the 3 brothers, Ram Hansda in his share got the house in plot number 532, where the plaintiff are still residing. Below the plot number 532, where the plaintiff used to reside, where the plaintiff are still residing. Ram Hansda had no son. Plaintiff number 1, Srimati Surajmani Hansda, alias Sariti Hansda, is his only daughter, who is married to plaintiff number 2, Devi Murmu of village Asojori, Plaintiff number 3 and 4 are the sons of plaintiff number 1 and 2. Defendant are descendant of Karan Hansda and Lakhan Hansda. Ram Hansda brought his daughter Surajmani Hansda and Devi Murmu in Agumit in the year 1957 and entrusted the cultivation and household affair to them, and in token of such bringing and entrusting the household affair, including the cultivation, the said Ram Hansda on 9th Asar 1357 is executed a Gharjamai paper in presence of the villager, signed by him and the villager, including father of the defendant number 1 and 3. Since that time, plaintiff number 1 and 2 have been residing in the house of Ram Hansda and have been cultivating the land. The plaintiff number 3 and 4 were born and brought up in the house of Ram Hansda. During the lifetime of Ram Hansda, the plaintiff helped him in cultivating his land and other affairs of the family. The village Pradhan sometimes back wanted to house the plaintiff illegally, helping the defendant from the two property mentioned in Schedule C of the
आप
plaintiff.
हमको सिर्फ पैरा 27 में आएंगे
Para 27.
पेज 23
27. Considering the entire evidence on record along with the facts and circumstances of the case, I hold that plaintiff was married to plaintiff number Surajmani was married to plaintiff number 2 Devi Murmu in saga or human form of marriage. Malod, exactly this is the case of the defendant.
right
And on that
which
basis,
was never converted into Ogmit Gharjamai.
which was never converted into Ogmit. And my lord, this is the very pivotal issue. Entire dispute
What
is
happened
hinged.
before the first appellate?
And the first, and moreover, my lord, it is a suit for the declaration of right title appertaining to Schedule C property. And my lord, kindly have a glance to the appellate court finding. Appellate court finding, my lord, I am referring, my lord.
Issue number 4.
Issue number 4.
The trial court recorded that it was never converted into Ogmit form, Gharjamai. But where is this issue before the
My
first
lord,
appellate court?
Before delving into the said issue, my lord, I would straightway come into the finding reported to the appellate court, my lord. Appellate court come out with a new case, my lord. My lord, kindly have a glance to page 28, internal page 28 of the appellate court judgment. My lord, on the basis of above analysis of evidence, it is held that the property of Bhaguru Hansda described in Schedule B of the plaintiff are the joint family property of the plaintiff.
We are not concerned with any of these. We are only concerned with the substantial question. Okay? What is the effect of Ogmit form of marriage? Whether Ogmit form of marriage was performed or whether ordinary or Chumna type of marriage was performed. So the learned trial court held that it was only Chumna type of marriage which was performed and it was not a Gharjamai form. Right? What about the first appellate?
My lord, the first appellate court, my lord, in a
Issue number 4.
in a very cryptic manner.
No, whatever be it. Where is it?
Point number
Page 6 में finding थोड़ी होगा.
And
Issue number 4.
7 to 14. It has been discussed.
Para 23. On the basis of above analysis of evidences, it is held that plaintiff number 1 was married with plaintiff number 2 augment Gharjamai form. Contrary finding of the learned trial court is held to be wrong. Para 23.
Para 23.
अब आप हमको ये बताइए, there is no finding, there is no substantial question of law regarding the correctness of this matter. नहीं है. There is a contrary, there is a, the learned first appellate court has set aside the finding of the learned trial court. Now the substantial question of law is whether this augment form of marriage will be equivalent to Gharjamai form of marriage. So you satisfied?
But the finding is otherwise, madam. Appellate court finding is otherwise, madam.
Does the appellate court say that it is not equivalent to Gharjamai form?
Madam, apart from madam that the finding of trial court has been disturbed by the appellate court, but in the ultimate madam, ultimately the appellate court come to a wrong conclusion and holding therein that the Schedule B property that is paritable in between the parties, and moreover, my lord, they given a finding that the plaintiff number 1 and 2, defendant of 1 and 2, and defendant number 3 to 6 is equally entitled to 1/3 share. That is not the case of the plaintiff, as set out in the plaint, my lord.
1/3 share of what?
1 share of the entire Schedule B property.
Schedule B property.
Schedule B.
You were claiming Schedule C.
I am claiming Schedule
Schedule
B.
C.
I am B and C also, my
No,
lord.
no. You are claiming Schedule C property.
My plaintiff is claiming Schedule C property.
You are the plaintiff or the defendant?
I am defendant.
Okay.
I am
All right.
defendant.
Plaintiff is claiming
Only Schedule
property.
C property, declaration of right title, and my lord, the recovery of possession appertaining to Schedule C property.
Okay.
But the finding is otherwise, my lord. The finding come by the learned appellate court that the Schedule B property is been divided 1/3 amongst all the parties. My lord, therefore, my lord, I am straightway.
As per the case of the plaintiff, how does the plaintiff arrive at Schedule C property
My lord,
from Schedule B?
my lord, there
The
are.
case of the plaintiff was
My lord,
that the Schedule B property was in joint name of 3 persons, right? Correct?
but it was not partition.
Maybe not
It
one.
was not partition.
So what? Even if it is not partition.
It was not partition, and it is not the case of the plaintiff that alternatively plaintiff has claimed for partition of 1/3 share.
No, she has not claimed. She says that I am entitled to 1/3 share. That's
That is not the case of the plaintiff. Plaintiff, consistent case of the plaintiff that the plaintiff is entitled on the basis of the customary law that she solemnized Gharjamai form of marriage, entitled to get protected and entitled to inherit the property left by his father. It is the case of the plaintiff.
So if the father
And
had left,
moreover,
whatever her father has left,
my
as per the plaintiff, she was entitled to that. Whatever was left by her father. If nothing was left, she was not entitled to
for
anything.
entitling, my lord, for entitling the property under Schedule C, my lord, the plaintiff should have proved his case, her case, my lord, but the plaintiff has miserably failed to prove that she has actually solemnized Gharjamai form of marriage, and moreover, my
Please
lord,
appreciate, Mr. Counsel, that is not the substantial question.
that is the substantial question of law, my lord.
Whether augment form is equivalent to Gharjamai form is the substantial question.
Here,
The first appellate court recorded that the marriage was in augment form In augment Gharjamai form.
In augment Gharjamai form, wherein the prospective bride used to reside in the house of his father-in-law. He was completely severed from the property of his biological father. Second, my lord, there.
Where is the finding
My-
of both the courts with regard to custom of augment Gharjamai form? What is augment Gharjamai form? Who claimed that it is augment Gharjamai form?
That has to be proved by the evidence, my lord. And my lord, in support of the Agumit Gharjamai form, my lord, they have adduced witnesses, my lord. Plaintiff has adduced witnesses, but the evidence adduced by the plaintiff did not support the case of the plaintiff, my lord. That has been discussed in the trial court judgment, my lord. Kindly have a glance to trial court judgment, my lord. My lord, kindly have a glance to page, internal page 12 of the trial court. Internal page 12 of trial court. Internal page 12. My lord, the 4 to 5 lines from the bottom, my lord. I am referring, my lord, start from EW1 admitted in para 7 of her evidence that Devi Murmu has his parental land in village Agojori. She stated in para 22 of her evidence that Salpu Tudu was the Jog Manji and Tanti Tudu was the Parmani on the occasion of her marriage with Devi Murmu, and they were alike. They are competent person to speak about the form of marriage of Surajmani Hansda plaintiff number 1 with Devi Murmu plaintiff number 2. But these two village officiates have not been examined and no explanation has been given for non-examination. These two witnesses are the star witness who could depose about the solemnization of the marriage of Surajmani with Devi Murmu as to whether it was an ordinary form of marriage or the Gharjamai form of marriage. And moreover, my lord, the Gharjamai form of marriage is been according to the Ganjar reports, my lord. What the Ganjar report said, my lord, with respect to the marriage, my lord, there are certain formalities which has to be performed for performing Gharjamai form of marriage. Here, after the solemnization of marriage, 1 year after the solemnization of marriage, father of plaintiff number 1 prepared a false and fabricated Gharjamai form of document, and it was produced before the proceeding in pending in between the party under 144 and 145 CRPC. अगर शादी हुआ रहता घरजामे में तो उसी समय डॉक्यूमेंट तैयार हो जाता। 1 साल के बाद आप डॉक्यूमेंट क्यों दे रहे हैं? और उसमें किसी का ना सिग्नेचर है, ना सील है, ना डेट है। With regard to my lord, issue number 4, my lord, the trial court has very elaborately discussed from page number 12 to 27. Meticulously examine all the evidence of the plaintiff and the defendant coupled with certain documents and come to the finding that the plaintiff has failed to prove the case. And therefore, my lord, and as such, the issue number 4 is decided against the plaintiff and in favor of the defendant. Reason has also been mentioned. While disturbing the said finding, my lord, the appellate court, in a very cryptic manner, came to the conclusion that it was an abhorrent form of marriage. Priest and Parmanik are the two important persons who could disclose as to what form of marriage was being solemnized, but they have not been examined. Then on what basis the appellate court come to the conclusion that it is an abhorrent form of marriage?
पढ़िए PW12 इंटरनल पेज 16 इंटरनल पेज 16 का बॉटम में PW12 इज मुगली मरांडी
Hoping to do. PW4, my lord.
PW12 page number 16 of that report.
PW.
Bottom में last line.
My yes line. PW web is Mungli Marandi. Mungli Marandi of Kathi, Georgia. She is daughter of my lord, sir, my lord, the Mungli here, my lord. It was an illustration of the case. कि हम भी एक ordinary form of marriage में शादी किए थे और they are entitled to inherit the property of his father. This is an illustration, but the law is well settled, my lord. For claiming the inheritance by a daughter, she must have performed the gharjamai form of marriage. तो जब वो परफॉर्म कीजिएगा तब ना यू आर इंटाइटल. जिसमें पढ़ दे रहा हूँ जो PW12 is Mungli Marandi of Kathgoria. She is daughter of Doman Marandi and she has no brother. She has 5 sisters and all of them jointly inherit the property of their father after his death. All the 5 sisters, after partitioning the land, cultivate it separately. In para 3 of her examination, she stated that she did not know how much land she had got from her father. Her evidence that the daughter of Doman Marandi, although married in ordinary form, gets good property of their father in preference to the agnatic relation cannot be accepted. What area has been allocated to her, she did not know. These are the illustration of a witnesses, my lord. Illustration of the witnesses cannot outside the provision of law, my lord. The provision of law for entitling the inheritance of the property by the daughter, she must have performed the gharjamai form of marriage, which has been duly gharjamai form of marriage has been duly performed by performing the certain formality.
She was the only daughter.
हुजूर इसको
She was the only daughter.
only daughter. She was the only daughter. आप उसमें हुजूर एक चीज जो अपीलेट कोर्ट का हम दिखाना चाह रहे हैं हुजूर, अपीलेट कोर्ट का एक चीज फाइंडिंग हम जो दिखाना चाह रहे हैं।
ये जो आप जो पैरा 46 ऑफ गैंगस्टर सेटलमेंट पढ़ रहे हैं ना, उसमें तो नहीं लिखा है कि ये कोई हार्ड एंड फास्ट रूल है।
नहीं तो उसमें तो ये भी लिखा है विद द चेंज ऑफ द टाइम, वो तो चेंज और
तो
जो लॉर्डशिप
इसीलिए
और
एविडेंस
लॉर्डशिप
में इसको लाना जरूरी होता है।
नहीं, लॉर्डशिप का जजमेंट
आपका
लॉर्डशिप का जजमेंट भी रिसेंटली आ गया है, तो इसीलिए हमारा जो रिक्वेस्ट रहेगा ना जो इसको नेक्स्ट वीक में पार्ट हट करके नेक्स्ट वीक रख दिया जाए, ताकि honestly my lord I have not gone through the plaint because the plaint WS is not with me my lord, और हम प्लेंट और WS इसीलिए हम देखना चाह रहे हैं कि जो डिक्लेरेशन ऑफ टाइटल विथ रिस्पेक्ट टू शेड्यूल सी प्रॉपर्टी है, अपलेट कोर्ट फाइंडिंग दे रहा है कि शेड्यूल बी का प्रॉपर्टी को आपस में बांट लीजिए, ऐसा कैसे होगा? हम डिक्लेरेशन मांग रहे हैं, देयर इज नो अल्टरनेटिव डिक्लेरेशन फॉर द पार्टीशनिंग of the property with respect to schedule B property. What has been actually awarded in plaint and WF, that is very important document. इसलिए हम हुजूर से रिक्वेस्ट कर रहे हैं कि अगर नेक्स्ट वीक इसको पाठा करके नेक्स्ट वीक इसी दिन में रख दिया जाए, हम आई एम रेडी टू आर्ग्यू दिस. दिस इज माय मोस्ट हम्बल सबमिशन बिफोर यू लॉर्डशिप.
रेंट रिसीट किसके नाम से कर रहा है?
रेंट रिसीट जो रेंट रिसीट है ना वो जो द प्लेंटिफ हैव प्रोड्यूस ओनली 4 रेंट रिसीट whereas one of the defendant has produced more than 27 rent receipt.
ओल्डेस्ट किसके पास है? ओल्डेस्ट किसके पास है?
लेकिन रेंट रिसीट का डिस्कशन है वो जजमेंट ये Appellate court judgment internal case 26 para 31 several rent receipt exhibit 323T were proved on behalf of the plaintiff. 323T only 3 rent receipts. Several
ये
rent receipts.
ये जो घर जमाई का जो पेपर है, ट्रायल कोर्ट इसको डिसबिलीव किया,
इसको डिसबिलीव किया,
एपेलेट कोर्ट
एपलेट कोर्ट इसको बिलीव कर दिया और ट्रायल कोर्ट जो डिसबिलीव किया तो देयर आर रीजनेबल ग्राउंड फॉर डिसबिलीविंग द सेम। पृष्ठ अजोग मांझी एक जामिन हुए और जिनके सामने बना था वो भी बोले कि मेरे सामने तैयार नहीं हुआ, जो कि इवन दे डिस्क्राइब जो सूरजमणि है, सूरजमणि बोलती है प्लेंटिफ नंबर 1 ये डॉक्यूमेंट मेरे सामने तैयार नहीं हुआ है।
That is not the substantial question. जो substantial question of law है, बस
ये
box के
कन्वर्ट
अंदर
इसीलिए वो
Convert.
इसको नेक्स्ट रख दिया
नहीं।
इसको फॉर द
No.
इंड ऑफ
What the ends of
for the
justice?
because my difficulty my lord
Your difficulty, see our difficulty
No, my
also.
lord,
In
my-
1991 का केस हम लोग 2025 में टेक अप कर
no my
रहे
lord
हैं।
I'm not evading for
You see-
judgment, I'm not evading for judgment।
हम जानते हैं ना,
जो
उसके बाद
इसको पार्ट हट करके कोई भी डेट रख दिया जाए
पार्ट हट करके क्या डेट रखें? फिर आप उस दिन एक तो नया
नहीं,
कहानी
हम नया
सुनाइए।
कहानी नहीं हम रखेंगे नहीं तो 2 दिन के बाद ही रख दिया जाए। इन द मीन टाइम आई विल गो थ्रू द प्लेंट एंड डब्ल्यूएस 2 दिन के बाद ही रख दिया जाए। हम नेक्स्ट वीक भी नहीं बोल रहे, 2 दिन के बाद रख दिया जाए।
You will confine your arguments to the substantial question of
मतलब
you undertake it.
हाँ तो वो तो सब्सटेंशियल क्वेश्चन जो और अगर इफ द केस रिक्वायर्ड माय लॉर्ड आई वुड फॉर्मुलेट द एडिशनल
I do not
I
know.
would-
आपका कोई पिटीशन नहीं है और ये सब कहानी हम सुने
आई वुड फॉर्मुलेट द
What do you-
एडिशनल सब्सटेंशियल
What do you mean?
क्वेश्चन।
How can you formulate it like this? Respondent appear हो चुका है, there is no petition, इसीलिए हम आपको टाइम नहीं देना चाहते। ये बाद में रिपेयर नहीं होता है ना, सेकेंड अपील बहुत टेक्निकल चीज है, बाद में रिपेयर नहीं होता। और ऐसा कोई सब्सटेंशियल क्वेश्चन ऑफ लॉ है ही नहीं। आप ही देखिए, आफ्टर appreciating the materials on record, the learned first appellate court has reversed the finding.
For reversing the finding, my lord, under the section 96 of the CPC, my lord, it is the bounden duty of the first appellate court.
That is not the substantial question of law.
But the law is well settled that the first appellate
Law
court,
is well
while
settled,
reversing the order, my lord.
that second appeal will be decided only on substantial question of law.
ठीक है,
इतना
तो-
फोकस्ड है सेकेंड अपील का जुरिस्डिक्शन कि उसके बियॉन्ड हम सोच नहीं
my
सकते।
lord, तो ठीक है, हम उसी पर कन्फाइन रहें।
करिए ना, कन्फाइन करिए।
कल मत रखिए, 2 दिन के बाद आप रख दीजिए, 2 दिन के बाद। इसको हुजूर
देखिए, ये जो आपका रिटन स्टेटमेंट फाइल हुआ है, इसमें कोई ऐसा प्ली नहीं है कि ऑगमेंट फॉर्म ऑफ मैरिज होने से आप इनहेरिट नहीं करेंगे। ऐसा कोई प्ली नहीं है, और ना ही कोई ऐसा प्ली है कि ऑगमेंट फॉर्म ऑफ मैरिज इज डिफरेंट फ्रॉम खजमाई फॉर्म ऑफ मैरिज। ऐसा प्ली ही नहीं है। एंड इफ such a plea is raised, then that has to be raised in the written statement. And Supreme Court का judgment है कि हर एक एरिया में, आपको पता है ना, हर 5 किलोमीटर में संथाल का लॉ ही चेंज होता है। And there is evidence on record that ladies are inheriting. There is indication in gangster settlement also that when there is no female, no male, then girls are inheriting. तो ये जो सब्सटेंशियल क्वेश्चन ऑफ लॉ बनाए हैं कि
नहीं तो बना है आपको 1992 में बाय दैट टाइम
92 से अभी तक सब सेकेंड अपील का लॉ चेंज हो गया क्या?
नहीं चेंज हुआ
हाँ,
तो
तो बस।
92 में फॉर्मुलेट हुआ था।
कोई बात नहीं।
10 दिन पटना हाई कोर्ट में हुआ था।
गलती किया पटना।
हम
आप बोलिए, हम तो नहीं लिख सकते।
हम कैसे बोल सकते हैं कि गलती
आप तो हम तो बोल कैसे सकते? बोल रहे हैं आप, कौन कैसे? The substantial question of law involved in this appeal is whether the marriage in augment form can be equated with घर जमाई form of marriage among santans. ऐसा आपका केस ही नहीं है। डिफेंडेंट का ये केस ही नहीं है कि augment form is different from घर जमाई form। जो अभी देखे हैं उसकी बात है। देखिए फीमेल्स राइट टू प्रॉपर्टी है,
My lord, तो there are
तो हम लोग लॉ के अनुसार ही
लॉ
डिसाइड
के अनुसार apart from my lord, the various pronouncement on this point by the Honorable Supreme Court, and your lordship had
Supreme
also-
Court has clearly said
and your
the
lordship
moment you say that there is a custom,
My lord,
you have to prove the custom. Now there is a finding that there is an augmented form of marriage.
who will prove, my lord? It is the plaintiff. Plaintiff will prove the case.
That finding is not under challenge in the second appeal. That finding is binding on you. The first appellate court holds that there was augmented form of
My
marriage.
lord, in the second appeal, only the decree can be challenged, not the finding, my lord. Due to that, my lord, my appeal is confined to the decree part only. Finding cannot be challenged in the 100. CPC does not prescribe for challenging the finding, my lord.
तो ये तो सब्सटेंशियल क्वेश्चन ऑफ लॉ ही आपके अनुसार गलत बन गया। दिखाए आपका सॉल्यूशन।
नहीं, 2 दिन के बाद 2 दिन का देख ले रहे, कुछ रिसर्च कर ले रहे, अगर कुछ होगा तो ठीक है।
अभी पहले एक जजमेंट किए थे जिसमें राजीवा शर्मा थी, अभी एक जजमेंट किए हैं जिसमें याद नहीं है
राहुल गुप्ता और एस के शर्मा
शर्मा, ठीक है। दैट इज बेस्ड ऑन द जजमेंट ऑफ सुप्रीम कोर्ट लक्ष्मी वाला।
2013 है।
उसके पहले वो कौन सा जजमेंट था जो पुराना चलता था, मधु किश्वर ने बोला है कि कोई स्टैंडर्ड हम ले डाउन नहीं कर सकते हैं, बिकॉज द लॉ कस्टमरी लॉ वेरीज फ्रॉम प्लेस टू प्लेस एंड इट विल डिपेंड अपॉन द एविडेंसेस प्लेस्ड ऑन द
But my lord, in Madhu Kishwar case, challenge before the ultra virus before the Supreme Court, section 7 and 8 of the CNT Act, which debars females to inherit or to claim
ultra virus ने ना किया है।
But it was not declared ultra virus by the Supreme Court.
Yes, therefore, in order to create a bar on inheritance, you have to prove the custom.
So it is who will prove? Who will?
Just
It
a
is
moment.
definitely the plaintiff
Just
will
a
prove.
moment. She claims that there was a augmented ghar-jamai form of marriage, and therefore she is entitled to inherit. Correct?
Well,
She has proved it.
she has not proved according to the trial court.
ट्रायल कोर्ट में आप फंस रहिएगा तो क्या?
तो जो इसको 2 दिन के बाद रख दिया जाए। I will try my level best to
आपको क्या बोलना है?
2 दिन के बाद ही बोलेंगे।
I do not say please. If you think so.
2 दिन के बाद बोलिएगा जो बोलना है। My lord, I liberty of your lordship to procure the soft copy of the
सॉफ्ट कॉपीज का नहीं मिल सकता,
print and WA.
इसलिए नहीं मिल सकता है
हाँ।
क्योंकि पूरा स्कैन होगा तो फट जाएगा। ये सूट कब का है?
ये सूट है आपको 81 का।
81 का है।
80 का है।
80 का।
आपका जन्म हो गया था 80 में? वेरी बॉर्न?
हाँ।
पक्का?
जन्म हो गया था।
एडवोकेट कब बने?
एडवोकेट तो 2000 से हम एडवोकेट हैं। सिविल कोर्ट में 1 साल थे, फिर 2001 से हाई कोर्ट में।
अब जजमेंट तो सब पढ़ लिए, लेकिन प्लेन रिटन स्टेटमेंट आपको जरूरी है।
हाँ।
मेरी तबीयत में बहुत है,
उर्दू तो देख सकती है।
कल हम छुट्टी पे रहेंगे,
ठीक।
रिकॉर्ड आपको मिल जाएगा।
कल हम रिकॉर्ड देख लेंगे।
आप देख
ठीक है, ठीक।
हम लोग भी
आप लोग देखेंगे।
यूजर का फोटो कॉपी का परमिशन हो।
फोटो कॉपी का परमिशन आपको मिल जाएगा।
ठीक है,
उतना
ठीक ठीक।
ये आपके लिए मार्क कर दिए,
ठीक है।
प्लेन और रिटन
हम
स्टेटमेंट।
यही देखेंगे कोर्ट में ही।
Learned Counsel for the Appellant has commenced hearing of this case on the Substantial question of law. Right. Order dated. (28) 1992. Which is as follows. He submits that he has to go through the records of this case and shall argue. Comments तो पहले ही सीटिंग comments हो गया. मंडे को ना
ठीक
10:31 केस
है
करें. ये सब का धूल से भी हमको सर्दी खांसी हो रहा है. सब खोलते हैं ना तो पूरा डस्ट निकलता है इसमें से. पेपर का डस्ट. डिफिकल्ट टू हैंडल.
उनका तो तबीयत खराब हो उसके बाद भी पूरा डिवोटेड टू सब ईच एंड एवरी पेज ऑफ द
क्या ही करेंगे.
प्रॉब्लम.
Order 41 will be 11 matters. दो दिन तो कॉल करिए. सोचे थे कि ऑर्डर 41 रूल तो लेकिन नहीं हो पा रहा है क्योंकि सेकेंड हाफ में कुछ मैटर्स पहले से पोस्ट. We'll try to take up those matters in the second half from the next week. आइए अभी कॉल करिए.
The hearing for hearing under order 41 rule 11 item 61 second to 4.
Counsel है अभी? आप हैं? आपका केस है? आपको देखने से लग नहीं रहा है कि आपका केस है. बताइए 2015 से क्या कर रहे हैं आप? लिस्ट नहीं हो रहा है. ये जो आप लोग का कहानी है ना बस ऐसे ही चलते रहते. अभी 2-4 सब्स्टिट्यूशन और होना बाकी है क्या? बताइए कौन मर गया? कौन मर गया बताइए. आप सब जिंदा है ना. चलिए बहस करिए. क्या मैटर है? टेनेंसी फाइंडिंग क्या है? हु आर यू? लैंडलॉर्ड की टेनेंट.
Tenant had decided, the tenant had disputed the title dispute. The trial court has held that the plaintiff has better title than the defendant. In an eviction suit, title cannot be decided.
Incidentally, it can be gone into.
They have to give a finding. What is the essential landlord and tenant is between the parties.
Where is the finding? Trial court का finding दिखा.
They finally come to the finding from the final trial.
You were claiming on what basis? On what basis were you claiming?
I was in the 1960 I am in possession. By that my
1960
Yes,
you are in
1960.
possession.
yes,
Okay.
by constructing the house.
Okay.
And the plaintiff purchased the property in 1980.
What is the title? You are in possession.
Yes.
How did you come in possession?
We have also been on recorded documents of title.
Sorry?
We have also been on recorded document of title.
What document of title?
That is
खतियान.
a-
You're the खतियान ही रही है.
No, it is a khas mal. It is a khas mal.
खास
It
नहीं.
is khas mal property.
State is
They have
party?
to take the permission. They have give the permission from the authority concerned. Now come to the finding also. But I have gone to design.
You have exhibited your lease deed.
Hello.
Have you exhibited your lease deed?
Yes, Lord.
Exhibit number.
That is exhibit A series also.
A series इतना सारा लीज डीड आपको स्टेट करके दे दिया. क्या है?
30, 34 and 36 onwards. Even then the court has come only on the finding that the plaintiff has a better title than you. That's why I am hold that you are taking.
And what is there any rent receipt which has been exhibited?
No, that is there.
The defendant, the plaintiff has not exhibited any
No,
rent receipt.
No, only a rent. No receipt has been. We saw that I am a tenant of the. Who is required to come to the family about the privacy of the contract of tenancy. That is known. And even the lower appellate court has not come on the point termination also. What rule 31. They have not given any point.
Exhibit A to A by 4,
By
which are the municipal rent receipts. You
that
said
is-
that you have exhibited the Khas Mahal lease.
small property is there. They have-
Khas Mahal property is given to a person by way of a lease
Yes.
executed by the state. Where is that document?
So that document is not there.
Municipal rent receipt से क्या होगा?
But all the document has shown. खाली कब पानी होता है. Which I want to show that there is no relationship of landlord-tenant between the parties. खाली कब issue also party the frame by the client. So five, is there any relationship of landlord-tenant with the plaintiff and defendant?
Show me the finding.
Now come to the finding which I want to draw. From which the child could have come to the finding that you are telling.
Where is that finding?
Now first I come to page number 50 Taco judgment. In the meeting.
Page number 50.
Page number 50 Taco judgment. In the meeting there is no any agreement or rent receipt filed on behalf of the plaintiff regarding dependent age tenants. Let's find it in the meeting.
Internal page 20.
Page number 15 also. Running page 45.
Yes, please tell me. Where is it?
In the middle of 60.
There is no any.
Since long more than 12 years, so there also it was. There is no any agreement of rent receipt filed on behalf of the plaintiff regarding dependents and age tenants. That is now come to the finding also. And thereafter the page 16 PW1 with the plaintiff, the PW1 examiner Tushira has also stated that premises issued by the SDO who has given the permission to sell the land. Although it is given by the deputy commissioner. Now the finding which I want to show, it is land of the Khas Mahal, it has come in the page number 17 also. Finding now say I have come. Page number 18 also in the middle. It intends to infer that the plaintiff has got in the suit better title than the defendant. And then the defendant has not counter-claim in the suit and complete portion of title can be handled in this. On this ground.
What happened by the first appellate court?
Now the first appellate court on the same view, without any public point department determination, also come to the finding that you are again on the same finding that you are tenancy is there. Finding is a page number 16 also. Without complying under court of 31. No point determination is there. That did we come to the finding. The title holder, the CJ land. Page number 12. Signed by hand, you have to prove that I am a tenant. You have deducted me as a tenant. And this is a rent receipt. That is not in the available.
Substantial question of law बताइए किधर?
Whether lower appellate court I failed to comply our protocol 31 in not framing any permit examination. Second, if there is a dispute of title dispute, then that the courts will require to establish the privacy of contract tenancy. That is likely by the finding of
देखिए essay number 450 of 2015. Or the learned counsel for the appellant. The learned counsel for the appellant has submitted that both the courts have submitted that the learned trial court has recorded that admittedly there is no agreement of tenancy and no rent receipt was filed by the defendant. The learned first appellate court, while recording the finding of landlord-tenant relationship, simply held that since the plaintiffs are the title holder of the suit property and therefore they are the landlord of the suit premises. The learned counsel submits that the relationship of landlord and tenant was required to be decided on the basis of materials available on record. Considering the aforesaid submissions, this appeal will be heard on the following substantial question: whether the learned first appellate court has erred in law by affirming the judgment of the learned trial court without appreciating the fact that there was neither any agreement of tenancy nor any rent receipt was exhibited. Whether the finding of the learned trial court and the first appellate court suffers from perversity while arriving at the finding of landlord-tenant relationship between the parties. ये ठीक है? Issue notice to the respondents for which requisites under ordinary process as well as speakers be filed by the appellant within a period of 1 week. ये तो अपीयर हो चुके हैं ये लोग.
आपको तो अपीयर हुए. ये नोट देखते. ये नोटिस हैज बीन गिवन.
ऑफिस इज डायरेक्टेड टू. अभी क्या चल रहा है वहाँ? पेंडिंग है मतलब इविक्शन सूट नहीं चल रहा है, मतलब वहाँ पर एग्जीक्यूशन नहीं चल रहा है. ऐसा चल रहा मतलब 2015 से 2025 तक आपको क्या ही जरूरत है सेकेंड अपील डिसाइड कराने की? Office is directed to call for a report from the concerned court as to whether any execution case has been filed pursuant to the impugned judgment and decree and what is the status of the execution case. खाली हो गया होगा तो हम लोग डिसाइड नहीं करेंगे, इनफ्रक्चुअस हो जाएगा केस.
राइट बने हम स्टोर करा के
क्या
फाइल करें थे अगर हुआ मेरा
अगला केस में अगला डेट में नहीं आएगा तो डीएफडी करते हैं, वो बेस्ट रहेगा. 2015 से ये आपको नहीं पता है कि एग्जीक्यूशन हो रहा है कि नहीं हो रहा है. जब पता है नहीं बताना चाहते
नहीं सर,
फिर कैसा है?
बताना नहीं चाहते कि नहीं हमको आइडिया नहीं.
आपको आइडिया नहीं है? 2023 में इसमें नोटिस हुआ, आपको आइडिया नहीं है?
वो तो मालूम है नोटिस.
फिर
यहाँ पे उसे आया
एग्जीक्यूशन केस में क्या हो रहा है आपको पता नहीं है? नहीं बताइए, बताइए आप हमको. 96 का इविक्शन सूट है, ठीक है? आपको पता नहीं है कि इविक्शन सूट में इविक्शन हुआ है कि नहीं,
हो भी गया तब तो हम अति करें सुन करेंगे लैंडलॉर्ड साइड
वो अलग बात।
हाँ बस
लेकिन आपको पता नहीं है कि इविक्ट हो गया है, ये थोड़ा सा अजीब बात है।
आप मेनू से आइए सीधा फाइनल लास्ट
Let the records be called for from the concerned. Communicate. हाँ नोटिस तो होगा ही, रेस्पॉन्डिंग नहीं अपील कर रहे हैं तो क्या ही होगा नोटिस तो। हाँ डेट 8 दिसंबर अवेटिंग सर्विस रिपोर्ट। एक तो हॉल कॉल करते हैं, देखते हैं।
Item 62 segment April 2 of
बहुत हमको ये
2016.
ऑर्डर 41 रूल 11 का हमको बहुत ज़्यादा चिंता लगा हुआ है कि ये टेकअप नहीं हो पा रहा है बिकॉज
Item 62.
यस
Before we launch now, today in court number 1
कोड नंबर 1 तो चल रहा है अभी,
जी चल रहा है.
क्या है ये?
He has requested me to inform this on the video.
ये मेरे बात का जवाब थोड़ी है। बताइए क्या है ये? Miscellaneous case 79 of 79. What is this, Mr. Manish?
My lord, I also only have the limitation petition on me.
Limitation has not been controlled.
No, it has been controlled. It has been controlled by order dated 12/5/2022. After that, there has been twice the appeals have taken place.
Miscellaneous appeal फाइल हुआ था, उसके अगेंस्ट में सेकंड अपील फाइल की।
अभी हम तो वेरीफाई करें तो पूछ लेते हैं.
यस 81 से चल रहा है कहानी। माइंड बॉगलिंग, आई जस्ट क्या हम इन केसेस का करें। Also for the financing settlement on the ground that Mr. Vibhas Sinha, advocate on record, who has to argue this case, is in court number 1. Post on next Monday.